Welcome back and thank you for staying with KTN Prime. We continue evaluating matters playing out in the judiciary. I'm joined by two constitutional lawyers, Kibe Mungai and Maxwell Miawa, as we evaluate some of the recent developments that have played out in the judiciary, the push and pull between some of the institutions under the judicial arm of government and what it means in the long run. Right before the break, I hinted that perhaps we'll take a look at some of the concerning issues that might arise from the legal battle pitting the Supreme Court judges and the JSC, and it's set to go on for quite some time. But let's get some legal interpretation, if we do say so. Miawa, I'd like your take on a couple of issues, because one of the issues that seems to be playing out, especially if you look at Justice Isaac Lenaola's petition, he questions whether a Supreme Court judge can be subjected to disciplinary proceedings from a ruling in which they were not involved in. I don't want to go into the details of the complaint that was filed, but the big question would be whether a judge can be removed over a ruling they were not involved in one way or the other.
Yes, the question of removal of a judge or questioning the conduct of a judge on the basis of the decision they have made is constitutionally protected. In fact, the Constitution insulates a judge from being questioned, from being examined, from being scrutinized on the merits of a decision they have made. Now, that is to say that one ordinarily should not bring a claim that a judge made a decision, a ruling, or a judgment which was, erroneous or another. Mm-hmm. The proper procedure is usually, if you are aggrieved by the decision, is either you apply for review of that decision or you apply to appeal that decision. But there are certain aspects to it. There can be circumstances when the decision of a judge is so bad, it is so lacking in reasoning that it can amount to incompetence. I think that can be the only one of the few exceptions where you can question a judge on the basis of a decision if the decision or the way the decision has been made speaks to some sort of incompetence, in terms of analysis, clarity of the law, clarity of the mind of the judge. Okay. It will be a difficult war to fight, particularly at the High Court, because if the Constitution says you cannot question a judge, you cannot scrutinize a judge, you cannot bring a disciplinary issue against a judge. It is perhaps different in circumstances where a judge is sought to be removed over a decision that he did not take part in. And I think that is perhaps is something the complainant needed to have reflected on. You cannot remove somebody from his position as a judge on the basis of a decision that he did not take. So the question of incompetence does not even arise in that particular case. Okay.
Yet another issue that might need interpretation, because the judges argue that the disciplinary proceedings are sub judice because the complaints under review are related to ongoing cases before the High Court, the Court of Appeal, the Supreme Court, and the East African Court of Justice. So does JSC's actions violate the doctrine of judicial independence, if you look at it from that perspective?
I think they probably, such claim of sub judice, the violation of separation of powers is arising from the parties depending on where they start. And I think those people who are arguing for the separation of powers doctrine are coming from the position that, look, in making a decision as a judge, the judiciary has got what we call institutional independence as well as, the decisional independence of a judge. And that in making a decision, a judge should not be guided or governed or should not overlook their shoulders to see what other people are saying or thinking. And so that's how the doctrine of separation of powers arises. So that whatever a judge does, cannot be questioned by anybody, any authority, any institution, including the JSC. That is the argument they are making. But people on the other side who are opposed to that argument are also raising the fact that, look, you can make a particular decision, but how you make it can be a fertile ground for removal, either because of incompetence or misconduct. For instance, there can be circumstances where a decision may be influenced by bribery, so one cannot insulate that decision under the doctrine of separation of powers because it can either be, that's clearly a question of misconduct on the part of a judge. So these arguments, the merits of these arguments are still before the court. I may not take sides of it. The sub judice rule also is arising from the fact that, look, the principal question in issue here was the barring of an advocate from appearing before the Supreme Court because of personal and personalized attacks against the Supreme Court, blanket condemnation of judges without evidence, without facts. And so the Supreme Court took a decision, a blanket decision, barring the advocate and all advocates in this firm from appearing before the Supreme Court. And then issues were raised, questions to do with fair trial. You know, when you bar an advocate, what becomes of the litigant who is before you? You know, you have condemned this person and heard who was the complainant in that particular case. You know, who was the jury? You know, you cannot be the complainant, the jury, and the judge at the same time. Those are some of the issues that are being litigated before the High Court, you know, the Court of Appeal and so forth. So that's how this rule comes. And I think the merit of that is yet to come. That issue can be separated from the complaint relating to or seeking to remove judges from the office on the basis of their conduct. I think those are completely different issues. Okay. Completely different issues. This is a complaint on the one hand. The other was a complaint by another another advocate before the High Court, and the matter has gone to the Court of Appeal. So I think we have to distinguish issues here and let the High Court do its work. Okay.
As you come in, Kibe, this matter of bribery and corruption allegations that have been circulating on social media, the JSC's handling of these allegations has been questioned by the judges in one way or the other. The judges accused JSC of failing to protect their reputation by allowing these unverified accusations to persist without demanding evidence. How should we go about this? Because it's definitely on the social media circles. Some of the members of the judiciary have been painted in bad light without actual evidence. This balancing act, how do we go about it?
Yes, before we come to that, I need to say something about incompetence. You know, to be competent, let's start there. You cannot be competent on a single event. If you say somebody is a good anchor, is a good journalist, it is a view you form over a period of time, a year or so. The same thing would apply to incompetence. That a single instance, just like a footballer, if he didn't play well today and he had played well 9 other times, that's a good footballer. But there may be a problem in one match. So for majority of the judges of Kenya Supreme Court, I believe all of them, it is not easy to stick a charge of incompetence on them. But you see now when you are having this kind of politically motivated charges where you are using certain decisions to say that these particular benches, all of them you are targeting 7, were incompetent, then because there are many grounds for removal. Corruption, misconduct, and now issues like incompetence. Now then incompetence now becomes a cheap blow. That now you want it to stick, but it's also the most difficult. And who will be the judge for that? Because ordinarily, if it is a magistrate, you say, what do High Court judges think of decisions that come from your court? Do they take of their... Now, when you're dealing with the Supreme Court, one would wonder, would even be a tribunal be able to examine, to say whether you are competent or not? So that for me is a fluid basis, ground for you to be able to remove anybody. But issues like misconduct, issues like crimes, bribery, and issues like this, those are more serious issues. And in fact, even across the world, you would actually get on more serious issues, misconduct and committing bribery and all these things as grounds for compared to incompetence. And again, very many Kenyans say, even lawyers, these judges, if ordinarily they have produced many decisions, why did you pick those cases? In fact, people can sometimes say, if one were to pick 5 cases where there is a consensus or badly decided by any court, either Court of Appeal or Supreme Court, these cases that have been picked may not even feature amongst them. To come to your question briefly, on bribery and corruption, The issue, there is of course some unfairness that if you publicize, it's like rape, by the way. If you say like so-and-so raped, the offense, I mean the injury to the person is committed by the allegation. The very allegation is injurious, even more than anything else. So it would be the same thing that if an allegation is made that somebody was engaged in any, and there is no investigations of any kind, we call it prima facie, to say, is there any credibility to this? Then you publicize that somebody was somehow corrupted. Kenyans would have a basis of saying, you paid your way out of it. So you actually suffer double jeopardy. One, by the injury of a false allegation being made, and secondly, by being told you act your way out corruptly. So we need to pay serious attention on that.
So all things said and done, gentlemen, as we finalize, there seems to be murmurs of a hidden political hand in the tribulations, the trials that are facing the Supreme Court judges, especially Chief Justice Martha Koome, who seems to have a target on her back. As we finalize, is there any truth to this? I know you're not politicians. What do you make of such allegations as we finalize, Kibe?
I think for me, I am certainly not a politician in electoral terms, but I try to understand politics as a constitutional lawyer. And what I can be able to say, and not just in Kenya, across the world, when you are having a president or any government, you've had it actually in Eastern Europe, Hungary and Poland, and those countries, you get the tendency of where the government of the day start trying to meddle with the system, with the constitutional system, in order to increase their chances for re-election or for retention of power. So that in the Kenyan scenario, and we are actually going to have more difficult times as we move on. If you have a secure government, a secure president who is confident that you are legitimate enough and you will be re-elected, there is a tendency, this is across the world, there is a tendency that you will observe the rules of the game, you will observe the constitutions, and you will let the people to re-elect you. But if you are governing the country in a way that is incompetent and that is not delivering to the people, then the chances are that because you want to retain power, but you do not believe, and it is obvious that you cannot be re-elected, then it is only by tinkering with the system that then you think your best chances for retaining power would lie. In the Kenyan scenario, and you've seen from recent history, the ultimate decision for a bad election, that you have rigged election, is that you would be afraid of a Supreme Court that you do not trust. Therefore, when the former deputy president said that when you do not trust that the people will re-elect you, you want to control the electoral cycle from IEBC to the Supreme Court, is a true reality. From not just from Kenya, across the world. That is how it happens.
Daktari, finally.
I think we have seen in this country the history of removal of judicial officers from office. Some of them have been brutal, inhuman. We saw the radical, what they were calling the radical surgery of the judiciary, which of course was largely a surgery of the judiciary by radicals. And it was one of the most vindictive exercises that we ever witnessed. Judges were removed from office, there was no notification, they lost their packs. And then came the judges and magistrate vetting board exercise, which in certain aspects was also very, very vindictive. And you would see something that there was not only a government hand in these removal processes. Some of them were individual lawyers, people who in one way or another during their years of practice had their personal grudges with the judges. Some of these lawyers were also in the ones that were involved in the bribery exercise of the judges. So when their cases in one way or another fail, they may have issues with one judge or another. So It probably may not be a political exercise, or the government may not have a political underhands in this. It could also be certain lawyers, legal practitioners pulling or triggering certain ramifications within the legal fraternity, within the judiciary. Okay. Vested personal interests.
All right, we'll see how it plays out. One thing is obvious is that Kenyans are a litigious lot. So we definitely expect a lot of court cases that might play out in retrospect to this particular scenario that is pitting the JSC on one side, Supreme Court judges on the other, even as the other judicial institutions, the Ombudsman's office equally weighs in on that particular matter. Gentlemen, we thank you so much for your time and your submissions, as it's commonly referred to in the corridors of justice. I was joined by Kibe Mungai, constitutional lawyer, and scholar and constitutional lawyer Miyawa, who definitely gave us his insights. That's how we wrap up tonight's edition of KTN Prime. Thank you so much for watching. On behalf of the team, including the sign language interpreter Maresha Owiti, we say good evening and have yourself a good night.